too much with the lawyer, but it's true, right? On various of these structures invoke legal questions that are only adjudicated later. And of course, we've seen litigation, tons of it, in the LME space. Fraudulent conveyance would be one, and Bill, you were referring a moment ago to the sort of the fiduciary duty of the companies. Like, the fiduciary duty of Josh and Noah is actually pretty straightforward and easy because they don't control the companies. Of course, if you have a chance to put capital out at a remunerative rate, you should do so. Of course, if you are on a credit, you should save your position, re-up, even at the expense of other lenders. You have no fiduciary duty I will give you legal advice right now publicly. You have no fiduciary duty to the other lenders in the group. The interesting one is that what Bill invoked was, well, from the point of view of the private equity sponsor, is there a duty to extend even the most thin of threads indefinitely into the future? And I think that is a test that interestingly it's extremely hard in retrospect to litigate fiduciary duties. Where's all the fiduciary duty litigation in real law? It's in M&A context, like during present M&A battles, or some, with minority shareholders versus controlling shareholders. There are precious few bankruptcy cases where creditors have successfully brought fiduciary suits against private equity sponsors for undertaking liability management transactions. And maybe that's okay, by the way, but it is probably the most interesting nexus of unenforced legal standards against the question, is LME good or bad? And let me give you one example of LME before it was called LME, which I always invoke, and I have nothing but love for the parties involved, but so be it. None of them will hire me again. In 2014, Toys R Us did a liability management transaction. By any other name, it was a liability management transaction. And they whacked up the capital structure. The IP was here, and the foreign business was here, and it was all made incredibly difficult in the sense that the business was parceled out to restructure. And what happened to Toys R Us when it went into bankruptcy? It did not restructure. It liquidated. And there's a very interesting thing about that deal in 2014, which was that a public company owned a very significant portion. I won't even name the private equity sponsor. Everybody knows, but I'm not going to say it out loud. A public company, who I also won't name, owned a very significant part of the deal. And when they did the 2014 liability management, the public company in their next quarter's financial statements just said, we wrote our equity down to zero. So I will not opine, because I am way out over my skis already and probably not going to be able to work again after this panel. But one might ask oneself, and Harvard can poll the audience, if a 25% shareholder marks their equity down to zero following a liability management transaction, is that a liability management transaction that should have gone through? Or should the company have just called it quits and filed bankruptcy at that point? Would Toys R Us still exist for my children? I'm going to be modeling my poor children. Had they not done that 2014 deal? It's a very interesting question. So these are important and interesting deals where these questions come up, like, should we do LME, should we not? On the one hand. On the other hand, should CERTA not have